Let's break it down with our attorney that's standing by. Michael Jaafar is with us. Michael Jaafar, let me start with you. Really looking forward to hearing your analysis of this one because it involves an insanity defense. And I know you have a lot of detailed analysis when it comes to just the history of the legal system and how they've approached insanity. So just tell me what you think of how it's being applied here and why it has changed over the years.
I think it's being applied the way it should be applied. I think it's changed over the years. I think I have an office in Cleveland. I know that a Cleveland jury right now is sitting there trying to find every way to not give her the insanity defense, right? The burden is on her to prove by preponderance of the evidence that she was insane. She did not know that what she was doing was wrong. Over the years, jurors have just tuned this out. I think it started with the whole John Hinckley thing. You know, he found, not guilty by reason of insanity, and he walks free today. I think juries have told themselves that if I give this person the insanity defense, she's going to walk out because of the fact that this involved the murder of a 3-year-old kid by a stabbing. I think that the jury is going to find every conceivable way to latch on and say, now we're not giving it to you. We're going to throw you in jail for the rest of your life. That's my theory, but we'll see what happens.
And Michael, we've got here a defendant who, no doubt, these jurors are taking in what she's looking like there at the defense table. But there was a moment during some of the pretrial hearings that really offended people because she was smiling. She was giggling at the defense table. And this is when her attorneys were asking for competency to get her evaluated because they didn't think she was competent to stand trial. That was denied in terms of the judge ruling that she was competent after she was evaluated. What do you think about what her demeanor is offering there at the table while she's in trial?
I think this is exactly the nightmare scenario for every jury, right? I think her demeanor is definitely not helping. This is why I started a little movement, didn't go anywhere locally, where I want to change the name of this defense from not guilty by reason of insanity to guilty and insane. It didn't go anywhere, but this is exactly why. I've been at that table multiple times with multiple defendants with this same type of thing, and it is not fun. It is terrible. It is awful. You see the look on everybody in the courtroom. They roll their eyes. It's just gross. It's grotesque, and especially given the fact pattern. So I think her demeanor is absolutely. These juries have found every way they can right now with her looking at her in that courtroom. I know they weren't in there when she was smiling, but they found every way conceivable to this person's a monster. And so the jury's going to look at her in that way, and her demeanor's not helping it.
Let's bring in our guests who are standing by with us. We have attorneys, Michael Jaafar. Michael Jaafar, can you weigh in on this competency issue? We've got this defendant who hasn't really asked in the past about mental health issues or evaluations, but now after a stabbing in jail, there's this question of competency, which isn't necessarily what we're seeing in the Bianca Ellis trial. My same theory applies in this case as well, right? Which is it's going to be very, very, very difficult. The burden of proof is on every single defendant to prove that, by a preponderance of the evidence that they were, insane. At the end of the day, this defendant has his own slew of issues. The Rule 14 violations obviously help him. So this case is going to be very interesting. I'm going to be watching this case and be riveted watching this case because this has been a saga that's gone on for a long time. And honestly, I want to see what happens. Snippet there from inside of the courtroom of a witness on the stand in the case against Bianca Ellis. Let's bring back in our attorneys who are standing by. We have Michael Jaafar. Michael Jaafar, we're going to continue to see people taking the stand like this because this happened in a public place. That adds so much of an aggravation to a case like this.
Yeah. Oh, absolutely. And I like how the defense attorney did not have any follow-up examination for the nurse. Excellent move on the attorney's part. And we are going to have to do that. Also, the state still has to prove every element of the crime beyond a reasonable doubt, which means they have to prove that the child died. The child died from the assault, and then what happened. They still have to prove it. So even though it's very sad, they have to go through the motions of their case, and this is what they're doing. And I agree. We're going to see a lot of stuff because this happened in a public space. So it's sad.
Yeah, follow up to that, Michael, is this brief interaction that prosecutors have pointed out when we're seeing her walking in. It's almost as if the mother, the victim in this case, has to swerve from hitting her. And then that's when you see the defendant turn around and come after the victims. Is that something that is been blown up a bit by the prosecution, or do you think that's a fair potential motive, that she was perhaps upset that someone was in her way or almost hit her? I think it's blown up by the prosecution. They have to throw everything they can at the wall, but I think it is blown up. At the end of the day, the defense is also going to argue that, hey, even though she had the knives and she was measuring them, she didn't know that plunging a knife into somebody and murdering them was wrong because she was insane. She was schizophrenic, and that was not a motive. She was not. She turned around. She was looking to stab somebody. She had no idea what she was doing, why she was doing it. So the defense have a lot of fodder that they can use to show that this woman was insane. Whether or not the jury buys it, it's a whole different story. But yes, this is going to be a very, very, very academic exercise for the defense, but not so academic for the jury.
Okay, while we're waiting for the next clip that we'll be able to show our viewers, there are some restrictions from the judge in this case. We want to make sure we abide by that. But I want to go back to the most important part so far in this case for these jurors, because this is what gave them the roadmap, and that's the opening statement. So let's hear a bit from the state and from the defense in what they laid out for these jurors.